Go ahead and start the hearing.
We're live.
Okay, thank you. With it, I'll call to order this hearing of January 9th, 2025. Got to change my date there. For case Z0135-24. Did I get that number right? Z0315-24. Get the right number. An appeal of a non-conforming use approval. My name is Joe Turner. I'm the county's hearings officer. I'll start with some brief announcements and a summary of the process that will follow, so everyone understands how you can participate in the hearing today. I start by saying I'm not a county employee. I am licensed as an attorney and trained as a planner. I serve under contract to the Board of Commissioners. I say that so you know you're getting a somewhat independent review of the application before me today. My role as the hearings officer is to conduct the hearing and determine whether the applicant sustained a burden of proof that the application complies with the approval criteria. In making my decisions, I must apply the county's existing laws. I am not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Board of Commissioners and Planning Commission to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As a hearings officer, I'm to provide an unbiased decision maker, and I believe I am unbiased with regard to the application before me. I have not had any pre-hearing contact with any of the parties regarding the substance of the application, and I don't have any interest in the subject property or any of the surrounding properties. But anyone has the right to challenge my impartiality, argue that I'm biased in one way or another, and you can do that when it's your opportunity to testify. This is a de novo appeal. That means the applicant continues to bear the burden of proof, and I do not give any weight to the planning director's decision. I'm required to make an entirely new decision regarding this application. Procedure will follow. I'll start by asking staff to summarize the director's decision and respond to the issues raised in the appeal. Then the applicant will have an opportunity to present the proposal and respond to the appeal. If anybody else wants to testify in support of the application, they may do so. And then I'll go to the appellant, give them the opportunity to present their appeal. And then anyone else who wants to testify in opposition to the application, in support of the appeal. Once everyone's had an initial opportunity to testify, I will give staff and the applicant alone the opportunity to respond to the testimony that was offered. If their responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing and announce what I'm going to do. Generally, I will issue a written decision within about 2 weeks after the close of the record. I'll send my decision to the county. The county will send it to parties of record. Anybody who testifies orally or in writing before the close of the record, I'll be sure and receive a copy of my decision when it's issued. Anyone with an interest in this application may offer relevant oral or written testimony, but testimony should be relevant to the applicable approval criteria, which are set out in the staff report, copies of which are available on the county's website. It is important that all parties make their best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals, or LUBA. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision makers know something about this application, you need to make sure it gets into the record before me. In order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me with enough specificity that people can understand what the issue is. If you feel you need more time to prepare, you can ask me to hold the record open or continue the hearing. If I hold the record open, you'll have an opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. But whether or not the hearing is continued or the record is held open for any other purpose, state law requires that I hold the record open for an additional week for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that right if they choose, but if anybody else wants me to hold the record open for a longer period, or hold the record open at all, or continue the hearing, you must make that request before the close of the hearing today. When you testify, please begin by stating your name and your full mailing address. Please spell your last name so I get it right. And if you represent someone else, please say so. There's no arbitrary limit to the length of time you can testify, but as I said, testimony must be relevant to the applicable approval criteria set out in the staff report. Also, please don't repeat testimony offered by yourself or earlier witnesses. Repeating your this isn't a popularity contest, so repeating your testimony doesn't make your case any stronger. The only issue before me is whether the application does or does not comply with the applicable approval criteria. If it does comply, can I ask everybody to mute their microphones? Ms. Jewell, I think yours is on. We're getting a little feedback. There we go. Thank you. When it's your opportunity to testify, but you can unmute yourself, but then remute again. Anyway, where was it? Sorry, I lost my train of thought. That was it. I think that's where I was headed. When it's your opportunity to testify, please state your name and full mailing address. Please spell your last name so I get it right. When it's your opportunity to testify, you can unmute yourself, give us your testimony. When you're done, please mute yourself again so we don't get the feedback issues. And then staff's going to go ahead and do their summary of the specifics of the online process. Ms. Ganser.
This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, both have audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by county staff moderator. Audience members' videos will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand features. If you're on a PC and iPad, you have a raise hand button on the bottom on the Zoom bar, on the top or bottom, depending on the device. When the moderator switches you over to provide testimony, your screen will look a little different for a while. Primarily, you will see all participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Be sure to provide your name and mailing address when you begin. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, email written testimony to mganser@clackamas.us. I'll show that on the screen later, or mail it to the Clackamas County Planning and Zoning Division, 150 Beaver Creek Road, Oregon City, Oregon, 97045. The staff contact email address is also available on the webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day that the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer's written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address to the staff contact for the application or by entering it into the Zoom chat function during the hearing.
With your staff report when you're ready.
Okay. Ready, is everyone able to see it?
Yes.
Okay. Today we'll be going over the appeal of land use file Z0315-24, a non-conforming use verification and alteration applied for by Pamela Jewell and appealed by Bennett Johnson. A brief overview of the site. The site is located at 28899 Southeast Woods Road in Eagle Creek. It is zoned RRFF5. It is approximately a 1/4 acre. It is adjacent to the Clackamas River and it is not within any urban growth boundary. A brief overview of the application. The applicant applied for non-conforming use verification for a detached garage that was built in 1962. The structure does not currently comply with the 10-foot side setback in the RFF5 zone, which is outlined in section 316 of the ZDO. The subject parcel became subject to zoning regulations in 1967. It was zoned RA1. The zone was changed in 1980 to RFF5, and that 10-foot side setback was in place at that 1980 effective date. In 2019, the applicant's husband added an attic to the garage with no further encroachment into the side setback. There were changes to the roof line, which did concern the fire department, which was addressed with a condition of approval. Staff found that the use existed prior to setback restrictions and with the conditions of approval to mitigate impacts. The 2019 addition did not create any adverse impacts, and our initial decision was an approval with conditions. The decision was appealed on December 16th. Here's a site plan seeing the structure here and its encroachment into the 10-foot side setback. The dotted line is the setbacks in this zone. And so you can see the encroachment right here. I'm going to give a bit of a high-level overview. I'm not going to go over every single criterion within the ZDO. For a more in-depth analysis, you can read my decision, which is Exhibit 1 of the record. Section 1206.04 addresses the discontinuation of use. If the use was discontinued for a period of over 24 consecutive months. The non-conforming use is a built structure, and staff was able to review aerial photographs and view the structure. In addition, the applicant in their original application, which is Exhibit 2, provided assessment data that stated the existence of the structure from 1992. And the former property resident attested to the garage's continual use from 1983 to 2015 when he resided at the property. This is the language regarding verification. This can be read in section 1206 of the ZDO, as well as in Exhibit 1, the original land use decision. My findings regarding the verification related to the appraisal records from 1992, which verified the existence of a detached garage structure built in 1962, which is the subject structure. The applicant, again, as previously stated, provided signed statements from Bill Bates, who lived on the property from 1983 to 2015. He attested to the garage's continual existence and use. Staff found that this use has been continual and uninterrupted since zoning and verified the non-conforming use pursuant to subsection 1206.05. From my understanding, the appellant is not contesting this verification. The primary issue raised with the appeal was related to subsection 1206.07b. Section A is related to alterations required by law, which is not applicable for this application. We're going to be looking at alterations not required by law, specifically subsection 4.1, which addresses greater adverse impacts to the neighborhood. The proposed alteration is the attic addition done in 2019. There was no change to the footprint of the structure, so it does not encroach more into the side setback. There was a change in the roof line with an extended eave. There was a concern raised by the Estacada Rural Fire District Marshal. She stated that it did create greater adverse impacts as the eave projection was too close to the residential dwelling. Exhibit 4A through C shows that. Hence, in conversations with the building code, which is in Exhibit 11, staff was able to impose a condition to mitigate these impacts to make the fire risk no greater than the risk of the original detached garage structure. The appellant states that the alteration does create greater adverse impacts because the increased height of the structure blocks the river view, which negatively impacts property values for neighboring property. Based on the photo that the fire marshal provided, this is Exhibit 4B, staff does not see how the attic impairs the river view any more so than the existing structure. Additionally, a video provided by the applicant's attorney shows the view from the road. And because the houses along Woods Road are up on a ridge line. There's not really a view to the river because you'd have to be looking down. And you can kind of see from this photo how the structure doesn't obstruct any sort of river view. And in addition to the trees, there isn't really a view of across the river either. And this has been corroborated with some written comments from neighbors, specifically the ones who lived across the street. And so with consideration of the statements from the appellant and their concerns, staff still finds that this criterion is met and that the alteration isn't creating greater adverse impacts related to the view. Going over some of the other alteration standards in 1206, the alteration or change will not expand the non-conforming use from one lot of a record to another. As stated before, there's no change to the footprint. It's not extending into another lot of record. It was verified pursuant to 1206.05, which is not contested by the appellant. The expansion, regarding the need for facilities to support the non-conforming use, driveways, on-site wastewater are not required for the support of this non-conforming use, nor would it impact those facilities. So staff finds that these criteria have been met as well. Regarding a condition of approval being imposed, there has been a condition of approval imposed related to the eave projection to address that fire code. So staff imposed a conditions to come into compliance with the Clackamas County Building Code. The building code officials provided guidance for several options that would get the applicant to compliance. These are listed in the advisory notes of the original decision, as well as, I believe, Exhibit 11, outlining the specific options that the applicant has regarding meeting the building code. Based on the original application and information received after the appeal, staff stands with their recommendation of approval with conditions for this application. And if anyone needs to contact me, my contact information and the mailing address are up here on the screen.
Thank you, Ms. Ganser. Could we go back to the photo of the structure?
Yeah.
I just had a quick question.
Mm-hmm.
So it's my understanding that the eaves on the left of this picture extend no further to the left than the prior flat roof on that structure. Is that correct?
I am not aware of how much the eave on the left extended. I know that the primary issue that fire raised was with this eave on the right because it touches the.
Yeah, I understand that. It was just my understanding you said that there was no further projection into the setback. And if the eave extends farther than it did, it would be a little bit more of a projection into the setback.
Yeah, when I review building permits, that we're measuring from the structure, the eave as an architectural feature is allowed to extend a little bit further into the setback. So that's why I made that statement.
That's what I needed. Do you have a code site in for that? And is there a limit to how far it can project?
I believe it is 1/3. I don't have the specific code right off the top of my head, but I can get that to you at the end of the hearing.
Okay, that'd be great.
Yeah.
That's the only question actually, it's my understanding the 150-day clock expires in 2 weeks at January 24th.
Yes.
Okay. Want to make sure that's something I didn't mention in my intro. There's a limit to how long I can hold the record open or continue the hearing. State law requires that I issue a final written decision in this case within 150 days, which is January 24th of this year, 2025. In this case, the applicant can extend that to accommodate the open record period. They're not required to. But the applicant's week of final argument does not count toward that clock, so that it in effect extends it for a week for the applicant's final argument. Thank you, Ms. Ganser. That's the end of my questions. Mr. Stamp, I understand you're representing the applicants.
Yes, Mr. Hearings Officer. My name's Andrew Stamp. I'm a land use attorney at VF Law. My address is 6,000 Meadows Road, Suite 500, Lake Oswego, 97035. And as you noted, I am representing the applicant, Pamela Jewell, who's in attendance here today. And if we would be willing to extend the clock out if it's needed. I don't think this is a case that I'm going to be going to circuit court on anyway, so
I appreciate the offer.
be needlessly expensive. So whatever's for the good of the order, I would grant.
Okay,
whatever
we'll
you
talk
need.
about that when we get to the end. If
Okay.
At
At this point, unless things change drastically, I don't need to keep the record open at this point, but we can revisit that at the end of the hearing. First, I'd like to thank staff for the excellent staff report. Ms. Kanzer did an excellent job summarizing the issues. There's really, I would say, two issues in the case. They both relate to the no greater adverse impact standard that is found in state law at ORS 215-130 sub 5 and sub 9, which is implemented in your code at 120607 B. And with regards to the issue raised by the fire marshal, I think you've already identified the problem with the eaves extending out further, particularly on the, I would say, what I'd call the front of the garage, the part that's facing towards the home. It was designed to give more of a sheltered area, but I don't think when that was designed, the building code was taken into consideration. So the condition of approval, I'm hopeful, is adequate to address any greater adverse impact created, because it's going to require modifications to the design. And as staff pointed out, the building code building official or his representative offered some different mitigation packages that the applicant could implement. And the applicant has hired an expert to figure out how to bring that into compliance to satisfy the building official. So I don't think that's an issue, although, it was a legitimate concern. So that brings us to the appeal that was filed by the appellant. Keep in mind that the fire marshal did not file an appeal. So even though it is de novo, I think it's fair to conclude that the fire marshal is satisfied with the condition of approval. So unless the hearings officer feels differently about that, I didn't want to needlessly run up the costs of this case.
I don't have any contrary opinion at this point, but I'll
Okay.
take any argument to that effect.
Okay. So that brings us to the appeal issue that was raised by the appellant. The issue is a little bit difficult to follow, but I summarized it in a letter that I submitted this morning. Kind of the chain of logic is that as follows: the appellant argues that property values in the neighborhood are largely based on land value, not the value of existing improvements. And for the most part, I'd agree with that. There are some really nice houses in the neighborhood, and then there's some that would probably benefit from some remodeling. So it's a mixed. It's mixed. So I would tend to agree with the property values lie in the land for the most part. Next, the appellant says any structure that blocks a partial view of the river creates a negative impact on other properties. And then says the value of some undisclosed neighboring properties are, quote, probably negatively impacted by the addition to the non-conforming structure. That's something I'm going to take issue with. And then finally, the appellant says, even though the appellant's property is not negatively impacted in any way, the mere fact that the value of other properties may be negatively affected is the reason that would cause every property in the neighborhood to lose value. And I would take issue with that statement as well. There's no evidence to support that, and it simply isn't true. But the essential premise of that chain of logic, however flawed it is that there is some property, or at least one property, that has a negatively affected view caused by the addition of the attic structure to the existing garage. In other words, that making this building from a low pitched roof to a higher pitched roof somehow impacts someone's view. And having been to the property yesterday and looked at it, I took a plethora of pictures, which we can go through, and that's simply not the case. Now, and without that essential premise in place, the chain of logic falls apart. So with that, I think probably, I think this argument that's being made really lives or dies on the photographs, the facts. This isn't really a case where the issues of law are critical. It's really the facts that are important here. So with your permission, I'd like to share my screen and find the pictures that I took yesterday and kind of walk through them.
That's fine.
All right, let's see if I'm
Especially
smart
since
enough.
I haven't had a chance to review them this morning.
Let's see if I'm smart enough to do this. Right.
So far, so good. There, yeah, we're seeing your screen,
All right.
seeing a bunch of pictures.
I took a bunch of pictures. All right, let me see if I can. All right, so this is a picture that I took yesterday from my client's property. Let's see, I got to get this out of the
Yeah, I
way.
was gonna say, at this point, we're still seeing thumbnails.
Okay. Oh, do you see?
No.
You just see thumbnails?
Yeah,
Uh-oh. Well, so much for being smart enough to show pictures.
I have to say I empathize with your technological issues.
Well, because I'm looking at my screen and it shows the picture, so I'm not sure what to do about that. But
And your mouse is not moving on our screen either. So I don't know why.
you know it. Maybe my screen. Maybe it locked up.
Maya, do you have the pictures? Do you think you might be able to do a share screen?
Yes, 1 second.
Would that work,
And-
Mr. Snow?
I'll bet you. I took it off screen share. I think probably my computer locked up for some reason.
If you want to try it again, feel free. And if Ms. Ganser can find them, that's great too. What if we can get them up
Yeah.
one way or another? Probably be more efficient if Mr. Stamp can, but we'll make it work. Really.
I'm going to try one more time and see what. Does that show up now?
It's loading. But yes, now we're seeing a picture of looks like a deck with a hanging basket and a view of the river.
Okay. Let's see. I just got. Oh boy. Man, I just got rid of that screen, so I don't know how to get back to it.
I have
Well,
all the pictures pulled up in a PDF. I can share screen and you can just
That
tell
might be the
me
best way to do that.
which.
okay.
Okay.
Apologize for the lack of technical expertise. I probably should have had someone in here to help me with that.
Okay, are we able to see the pictures?
Yep, we're seeing
I
that
see.
same one we just saw on Mr.
Okay.
Stamp's screen. Okay.
All right, so if we just keep scrolling down these pictures, I'll
That'd be, yeah, that sounds good.
now, the main thing you can see in this second picture is you can see the river and that there's a little bit of topography there. So I'm standing on the deck in this picture and you can see I'm probably 15 feet higher than the river. So I'm guessing 15 feet. I haven't taken a formal measurement, but you get the idea. There's some topography. And the reason that's important is that anyone who's standing back on the road can't see the river, even if there's no buildings. I mean, even if there was no houses there at all, you kind of have to walk to the edge of the terrace to see anything. That's the critical fact that you need to know. All right, keep going with the pictures. Okay, just another view there. All three of those. This is a picture taken on the deck. Not terribly essential picture, but kind of good for background. Keep going, please. All right, this is a picture of the, there's a small shed in the front, which the applicant said that she was going to remove at some point. But behind it, you can see the shed. And there is a picture in the file that was submitted with the original application that shows the shed prior to the current, prior to the roof being raised. And I think that picture may answer the question, although it's not entirely clear. I think it answers your question about the projection of the eave on the other side. It looks like it's pretty close. It may be, if it's projected any further now, it's only maybe a foot or so. It's pretty minimal. It's not like it is on the side that we're looking at where we can see clearly. It projects out 4 feet or so on that one side. The other side doesn't match that. Okay,
And,
keep going.
Regarding the photo you're referring to, I didn't see it in the record. I just skimmed through Exhibit 2 and did the application, and I didn't see it there.
Oh.
I remember looking for that when I was originally reviewing.
There is a picture that was given to me, and I
Yeah.
thought it was with the application, but I can.
Yeah, it sounds like staff reviewed such a picture. I just haven't. It wasn't included in the record that I received.
I reviewed aerial photographs that were
Oh,
available
okay.
to us, but I haven't seen that, so I don't think it was an application. Also,
Okay.
the code section related to eve projection is 903.05A.
Thank you.
Oh, I know where this is. This is a picture that appears. It's probably on Zillow, and I can put that into the record.
Okay.
I'll do that today. Because it says 2013 on it. That may be a photo that we got off Zillow. Because I know I didn't do it, but my assistant said she did. Okay, well, that picture's obviously upside down.
I don't know.
So that's not going to help us right now. We can keep going. Let's keep going, scrolling through these. I'll stop you when I get to something important. Here you can see the terrace. You can see there's a grade differential there. Keep going. Keep going. I probably took more pictures than I needed to, and I was in a hurry, so I just threw them all on the record. Keep going. All right, this may be the important one here. Okay, yeah, this picture is really good for a couple different reasons. This one and the next picture show I took this picture close to the water. I'm not exactly on the water, but it was about the point where it started to get muddy and didn't want to get my shoes dirty. But you can see how the structure at issue, the garage, is set back closer to the road than either my client's dwelling and the neighboring dwelling to the right of the photo. And that's important for a couple reasons. One, if there's any concern about views from oblique properties that, in other words, not directly across the street from my client's property, but kind of oblique to either angle, those views would be blocked either by my client's dwelling and the 2-story house right next to it. So the only 2 properties that would even be in question are the 2 that are directly behind my client's property, and those are lots 36 and 37. I did put a tax assessor's map in there so that you could reference that. And I do have some photos of those properties, and so that's critical because you can see even if you had the shed structure was down about 5 or 6 feet to its original height, you can see behind it that you'd have to be up in the trees somewhere to see over the top of that original structure. So basically you'd have to be on a second or third story, and maybe even a second story wouldn't be enough. It's hard to say exactly, but there's no ground view of the neighboring properties that would be affected in any way by approval of this application, is what I'm saying. When you're making a comparison of what was there, the original non-conforming use compared to the addition, the alteration, which is the legal comparison you have to make. And I did cite a case in the record that emphasizes what the legal standard is there. It's comparing what was there with the original non-conforming use compared to the alteration. You know, the difference there, did that create an impact? Okay, and so you can see here that there isn't a view. Keep going, please. Couple more photos. Probably didn't need to throw all of them in there, but I did. There's the neighbor's house. You can see it's 2 stories. And that neighboring house blocks a lot of oblique views. Keep going. It's loading a little slowly, but big file, I'm sure. These are just a couple more pictures of the of the site. That picture really shows the problem that the fire marshal identified. The 2 eaves are kind of almost touching, which creates the fire danger. I did throw in a few pictures of the inside. Not particularly relevant, but in the event anyone was curious, you can tell that there was structural work was done inside there. So this is a picture that shows in the middle there. You can see a 2-story structure. That house right there would not have any view that's altered because from this oblique angle, the neighboring property would block any view that they have over where the garage would be. In other words, even if the garage wasn't there, they would just be looking at the neighbor's house. Okay. Now, one other thing that's worth pointing out, you can see my car is there, and right behind it, could you go scroll back up a little bit? My little Camry's right there, and behind it is a vacant lot. I've been told that that is a non-buildable lot because it is where the wells are located that serve a lot of the development, and perhaps my client could opine on that, but we don't need to worry about views from that lot because it's not buildable. Okay, keep going. Now this is the house that's directly, oh wait, I think you went too far.
This one?
Yes, ma'am. This page 22, I think, of 35 there. This is the house directly across the street from my client. And I talked with the owner of this lot last night. He did submit an email in support of the application. What's telling about this photo, though, is that obviously the landscaping that he's created there is intended to create privacy for him. He's not concerned about his views. And he told me last night, and he may be here today to testify, but he told me last night that he didn't have a view no matter what, even if the garage were not there, even if it was gone, he still wouldn't have a view of the river. And he was apparently friends with my client's now deceased husband, spoke very highly of him, spoke very highly of my client, and is in support of the application. Okay, keep going. Just some other photos there. You can see okay, this one with the truck sitting in front of it. This is lot 36. And I don't know if there's a house there or not. I couldn't really see anything because all the landscaping kind of blocks any view that they have. Here again, this lot is not concerned about, obviously not concerned about views because they've structured their landscaping in a way that kind of hides whatever it is they have back there. So
Where is this, excuse me, where is this lot in relation to the site?
it's a little, the other lot that I just talked about is directly across the street.
Mhm.
And this one's a little bit to the east of that. It's the next lot.
Okay.
And this is the only other lot that would have any kind of view, theoretical view, that could be affected. In other words, those are the only two lots that are in close proximity to my client's property. And obviously both of those lots are not, their landscaping indicates they don't really care about a view. They're more concerned about privacy. Okay, keep going. I think those probably don't. Okay, so there's a house that has further to the east, and it's so oblique to my client's property that there's nothing about the garage that would change those people's view of anything. Because from that view, my client's house would be in the way of their view shed. Okay, keep going. This is taken kind of from the oblique view. Could you go back up a little bit?
Mhm.
There you can see, I'm standing up on the right of way. You can see the shed there. And obviously the river's way lower than that. So, I mean, even if the shed was, 3 or 4 feet or 5 feet lower to where it originally was, you wouldn't see anything other than some trees back there. You definitely wouldn't see the river. Okay, keep going. We'll run through these really quickly. Just another couple more views. Yeah, like I said, it probably didn't need to submit all these, but I was kind of in a hurry. This shows you right here, the oblique view. You can see that the neighbor's house, even if my garage wasn't there, the house would be there. So that from that oblique view, it blocked the house. The neighbor's house blocks the view. So that's the reason for that photo. Okay, keep going. Similar, showing the oblique view. This is a picture of the appellant's property. It's way down the street, and it has no. I mean, it's so far away. It's completely removed from I'd say it's a couple hundred yards, maybe 300 yards to the east of my client's property. It's not built on, and its views are not affected. Okay, keep going. Just an additional perspective. Few more shots there. No big deal. Okay, so this is kind of interesting. This is a photo that is taken from the right of way. I was driving down the road, and you can see here the river's back there, but you can't see it from the road because of that terracing issue that I talked about. So this is probably the best view of the river that I could have gotten anywhere. And I can't even see the river standing. I think I was standing here. I might have been sitting in my car, but you just can't see anything. Okay, keep going. I think that might be it for the
That
photo.
was the last photo.
Okay. There is a video that I took, and I won't bother to go through it, but I did something where I went down the entire subdivision in my car, holding my video camera, kind of driving and videoing at the same time. Safety third. But that video gives you a perspective of what the view is from the right of way. And there's so much built up, that first row of houses is so built up. I don't think I ever saw the river from the right of way. And that video that I submitted, it's about a 2-minute long video, and it'll show that. Okay. So in light of that, I think the factual premise for the appeal that property values go down because this structure blocks somebody's view is factually incorrect. And without that essential premise, there's no way to draw a conclusion that there's an increased impact to the neighborhood based on a loss of view comparing the non-conforming use or non-conforming structure, I should say. And it's not a non-conforming use, it's a non-conforming structure due to setback. And I guess that's a technical difference. But, you know, comparing the structure with the original roof to the roof as it is now does not change anybody's view of anything other than perhaps a few trees off in the distance. And whatever effect, there's no evidence that that would have any effect on property values at all. And I submit that they would have none. So without that factual premise, the appeal fails. So I think that's all I'd like to say. My client is here. I don't think that we need, you know, unless you have some questions for her, I don't think that there's anything else to cover, unless some new issues are raised during the opponent testimony, which if they are, we'll address them on rebuttal. But if Pamela, if you'd like to say something, this is your opportunity. Can you hear me?
You'll need to unmute yourself, Ms. Jewell. You're
Ms.
still
Jewell,
muted.
can you hear us?
I think she can. I can see her talk. Yeah, she,
Okay,
but you're muted.
if you'd like to talk, you need to unmute yourself.
Okay, hi.
There we go. Now we're hearing you.
And I will mute myself.
Okay, the,
Ms. Jewell, we're getting some feedback. It sounds like you might have two things on. So if you can mute one of your,
okay, now is it better? Oh,
no,
crying.
you're still echoing. Now you're muted. Okay, you're unmuted.
Okay,
It's still echoing.
okay, I'm gonna go out of this one. I am so sorry. Goodness.
We're still getting it.
Ms. Jewell, I don't think you really need to testify, and given that you've got the problem with the audio, maybe.
I think you're correct. I think I fixed it,
Okay, there
You
you go.
did. You
but
did.
I hung up the phone.
Okay.
Okay, the only thing, when you were going through the pictures,
Ms. Jewell, can you
photos-
just state your name so we know somebody's listening
I'm
to
sorry.
this? They know who's talking.
I'm Pamela Jewell. I
Thank
live
you.
at 28899 Southeast Woods Road. And you did a good job, thank you. The only thing, that extra picture that you couldn't see the house, that's part of the other person's property who filed the statement.
The one with the two vehicles
Correct, correct.
under the brush. Okay.
Correct.
Thank you.
The only thing I was going to say is when my husband started the attic in 2019, we then had COVID. We were evacuated for the wildfires. And then in October of 2020, he was reevaluating, looking at the roof, and he fell off the roof and was life flighted to a manual. Subsequently, the next long time, well, until 2022, was in the hospital, out of the hospital, had his last surgery February of 22, and was and passed away from a major stroke in May of 22. So after that, I've just tried to pick it up and get the permits and do the legal things to do. Our home that we remodeled, we did all of the permits and all of the inspections until completion. So thank you very much. That's all I have to say.
Thank you, Ms. Jewell.
You're welcome.
Right.
Thank you.
So
Thank
Mr.
you,
Turner,
Champ.
I think that's all that we really want to say in our case in chief. Unless you have any questions, or if you think there's some evidentiary holes that you would like me to fill in some way. You know, it's hard for me to, having been to the site, it's hard to know whether the pictures, you know, do as much justice to actually being there and seeing it. But, oh, I did have one other thing that I forgot to point this out when I was going through the pictures, but one thing that I noticed when I was on the site is that Miss Jewel's house probably is about 3, maybe 4 feet higher. I'd say probably 3 feet higher than the right of way. In other words, ground elevation's a little higher.
So like
And
the ground at her foundation is higher than the ground at the right of way?
yes,
Okay.
it's somewhat subtle. It may not show up in the photographs, but it was definitely something I noticed when I was there. And the reason that's important is that if you're on that ground level on the right of way, you've got a few feet in addition that you have to look over the top. That's one of the reasons you can't see the river. And so anyway, I thought I would just point that out. But other than that, like I said, I think the facts are really important here, and that's why I went through and made sure that you had a lot of photos to look at. Because the best way to figure out whether there's a view effect on views is to visualize it. And so I hope you find those photos helpful. And that's really all I have to say right now. We'll listen to the other people speaking and come back on rebuttal if needed.
Okay, thank you, Mr. Stamp. I would like to see the photo you referenced of the original structure, just so I can compare that. That would.
Okay, I'll have that emailed right now. I'll be right back. You can go ahead and. keep
Okay,
going.
thank you. Is there anyone else who'd like to testify in support of this application in opposition to the appeal? If so, please click on the raise your hand button to indicate that you'd like to testify. I am not seeing any raised hands, but I'm afraid oh, there we got 2 of them.
Mr. Turner,
Okay.
we have a couple of hands.
They went up right at the same time.
First, I have Ron Niger, followed by Tom Palmer.
Okay. Mr. Niger, you'll need to unmute yourself. Staff has unmuted you.
Can you hear me now?
Yeah, we can.
Very good. My name is Ron Niger. I live at 8145 Southwest Valley View Drive, Portland, Oregon, 97225.
Okay.
I have a home in Twin Island. It's a riverfront home. I bought it in 1974. So I've been there more than 50 years. I'm finding this hearing a little disturbing. There's really nothing that I see. The issue should never have been raised in the first place. The garage was there. It was ready to fall down. I knew Bill Bates, who was the previous owner, of course. He was a good neighbor friend. And I guess my premise is that as I read the appellant's, I got 2 pieces of paper where the appellant is saying a bunch of stuff that really isn't true. I don't get what's going on here. I think this is a nuisance kind of a situation.
I have to consider the appeal the issues that they've raised.
Okay, I'm going to address that.
Okay.
Across the street from I have a riverfront place.
Mm-hmm.
I'll say one thing. From the kitchen in my riverfront place, I cannot see the river most of the time.
I'm assuming your kitchen faces the river.
My kitchen faces the river.
Yeah.
It's in the back side of the house.
Okay.
Let me say this. I have to be in the front 20 feet of the house in order to see the river at most times. Unless it's flooding. Every once in a while we get floods through there or high water. And of course you can see the river at that time from the whole house, but not from the road. You still can't see it. The river is about 15 to 20 feet below my property where my home sits. I've got a neighbor across the street. It's a 2-story house. I've been in it in the past. From the second floor, you can't see the river. I would estimate that a person would have to build a house at least 4 stories and stand in the top story before they could probably get a glimpse of the river at any point in the property. The next point I'm going to make is There are 80 lots in the Twin Island District, 80 of them. I own one of them. And I will state that probably none of those 80 lots are more than 5 feet or even 3 feet higher than mine. All of that land in there is flat. And there's no way anybody but the riverfront people can see the river at all, probably even in high water. And that's my point. I'm disturbed by what's happening here. Ms. Jules has improved her property immensely since she bought it, since she and her husband bought it. And I submit that the garage is an improvement to the appellant's property, not a detriment. And with that, I'm through.
Thank you, Mr. Niger. And if you'd please click on the raise your hand button again, so we know you've had the chance to testify. Mr. Palmer, you'll need to unmute yourself.
Yeah, can you hear me now?
Yep, we can.
Yeah, my name's Thomas Palmer. I live on 29092 Southeast Crest Drive, Eagle Creek. I own the property between the river and Pan Jules land. And I'm just here to say that, yeah, there's a significant lower elevation of the river than where all the houses sit. And there's just no way you can see the river from the road, hardly at all, if at all. I frequently ride my bike down that area, and I'm right in front of Pam Jules' house when I'm riding. And there's just no way you have a river view from a bike riding down that road. And just to reiterate what everybody else has said, that's no way is that garage affecting anybody's view, let alone the addition.
Okay, thank you. Mr. Palmer, if you'd click on the raise your hand as well. Is there anybody else who'd like to say something in support of the application? Okay, not seeing anybody. It's the appellant's term. Ms. Johnson. And Ms. Johnson, you'll need to unmute yourself. I'm not seeing Ms. Johnson though.
I'm here.
Oh, there you go. Okay. You disappeared from my screen for a minute there. There we go. Go ahead, Ms. Johnson. Can we get your name and address?
My name is Bennett Johnson. My address is 816 26 Road, Axtell, Nebraska.
Okay.
So I can just go?
Yeah, go ahead.
Okay, so I'd like to say that first that I was told that I needed to submit any testimony, written testimony or whatever exhibits a week before this hearing. And I thought that was a deadline. So since then, there's been a lot of things submitted. And so my original testimony my original statement doesn't include some of the things that I'm going to say today. Is that okay?
Okay. Yeah, and if you want, that's absolutely, if you want, I can hold the record open. So you
Yeah,
can
why don't
additional
we,
written if you want to, or no
why don't we-
photos. Or whatever.
okay, why don't we see how things go?
Okay.
We
Sure.
can decide later on in this proceeding.
Okay.
I did also want to mention that I had a limited time here where I live in Nebraska. Mail is extremely slow, and it takes weeks to get here from Oregon, unfortunately. So I got this just I'd say probably about 5 to 7 days before the deadline for the appeal. And I did call Pam Jewell and left a message to chat with her about this, but I didn't hear back from her. So in order to meet that deadline, I went ahead and put the appeal in. And so in some of the things that I don't have an attorney here, it's just me. And some of the things that Mr. Stamp said, I'm going to try to respond to a little bit, because my main concerns there were 3 main things that I was concerned about. It's not so much as he said, my property doesn't have any structure on it. And by the way, the pictures that he showed, there's only one of them that actually captured my property. My property overlooks the river, and he was actually taking proper pictures of the property next to it. So it's not so much that I'm concerned about the property value right now as I am in the future. Certainly I am concerned about it right now, but this is investment property for me.
Sure.
And if you drive around down in Twin Island Park, you will notice that there's a lot of, as he said, a lot of nice houses down there that are well kept. But there are a lot of other ones that probably are on their last legs. And it's my hope that as time goes by, that the buildings, some of those structures will come down and other ones will go up in their place. It's kind of like if you own property and somebody, everybody keeps their yards up and their houses up really nice, and there's one property that has a bunch of dead cars and is falling over and doesn't get painted, that property is going to drag down everything in the area.
Sure.
And conversely, if you build something really nice, it's going to start dragging it up. That's my hope, because this is property that is on the Clackamas River. It's extremely desirable. And there's two developments down there, Paradise Park and Twin Island. And both of them are kind of, on the downhill slide. So I would think that over time that people would scoop up some of these pieces of land, scoop up houses, either remodel the houses or tear down those structures and build future ones. So a future, to what he said about you would have to have a second floor. Absolutely, you would have to have a second floor, but the properties on the other side of the road can have a view of the river. I've been down there, many times. And that's what a lot of them have done, is build a second story, have their living room space in the second story so that they can actually have a partial view, maybe not an unobstructed view, but a partial view of the river. And of course, any view of the river is going to bring up the property value. And anytime a property value of one property is increased, other properties, specifically mine, is going to be increased subsequently. So let's see, what else was there? I didn't get a chance. He said that he submitted a letter this morning. And of course, I haven't been able to look at that letter. But again, I thought that we were talking about a deadline of about a week ago. And let's see. So my main things were that that the property values would be the more properties that have views of the river, either because they are sitting on the river or because they are able to manufacture a view of the river by building a tall enough structure, those properties will help to increase the values, including the value of mine in Twin Island. The other thing is that, and this is a big issue for me, is that Ms. Ganser was nice enough to call me up about this when I originally emailed her and asked about appealing this. And she explained that she explained the whole thing about the original building built in the 1960s, and that one, there were no codes in place. So I understood all of that. But I said to her, the county doesn't do anything unless there's some type of event that causes them to look into something. And so they're basically complaint driven. And so what she said was, yeah, there was an issue. So at the time, I didn't know what the issue was, but I'm going to get back to that a little bit later, because the actual nature of the issue, the thing that actually brought all of these properties into focus and review, is something that is of great concern to me. But I'll come back to that, because what I wanted to say is that there are so many code violations down in that neighborhood that you don't have to get out of your car. You can just drive down the road and see, you know, code violation after violation after violation. And because the county only addresses violations that are made, or because the county is complaint driven,
Mhm.
then they don't address all of these. And every single one of these code violations, in my opinion, serves to drag the property values down in the entire neighborhood. And so I think that anytime the county allows one of these code violations to you know, continue, is adversely affecting the property owners in that area. And really of great concern to me is that there are some properties down there that they are blatantly doing things, have blatantly built, you know, non-conforming.
I understand, Ms. Johnson, and I see that in a number of places, including my own neighborhood. But
Yeah.
the only way to address it is by filing a complaint with the county, reporting those. You
Mhm.
have to be the complaining party, or somebody does, because you're right, the county does only respond, address violations.
Precisely, which is why I'm complaining.
Okay,
And so,
about this
yeah.
one, yeah. So
Yeah,
like I
and
said,
so-
if you have other issues with other properties, I understand, and file a complaint, and the county will address it, but
Mhm.
unless somebody does.
Oh, I have. And I've
Okay.
had the county, you know, I've filed complaints about barking dogs and, you know, not barking dogs once in a while, but barking dogs that barked, you know, incessantly. And the county has said to me, you know, we're not addressing that these days. We're choosing
The
to not.
county does now address barking dogs. I'm also their hearings officer for dog control hearing, so I know that
That's
very
right.
well.
That's where I knew I'd seen you before. And I
Really?
think you actually, yeah, I
Okay.
kept thinking, where have I seen him before? Okay, great. So, okay, so the thing that is of, okay, so you understand where I'm going with, I don't think that variances and waivers should be the standard protocol. I think that, and so what I found out later after we started doing some more investigation was the complaint that came in was basically from the fire marshal, and who was saying that we don't know that we can fight fires adequately down there because of all these code violations, including this one.
Mhm.
And so, you know, if a fire, and someday this will happen, burns in Twin Island, God forbid, then it's going to, you know, particularly in the summer or time of year where the, you know, 10 decades worth of pine needles that have been falling out of those trees lights up and goes up the side of that hill, is not only going to impact the folks that are in that neighborhood and the neighborhood next to it, Paradise, but also the neighborhood that is up the hill,
Yeah,
Mr.
I
Palmer
understand.
lives
I was
on.
very
Yeah, I mean, it's
familiar with
gonna
the
go up
area.
that hill like a blast furnace.
Yeah.
And, you know, and we're sitting watching California burning up right now. And so the fact that this fire marshal is telling you, you know, we used to be friends with one of the police chiefs in
Ms.
Estacada.
Johnson, if the applicant has to address that one way or another. If I
Mhm.
approve this, they have to fix it by doing what they said in the staff report, firewall, or pull the eaves back or modify it to fix that fire issue that the fire marshal is concerned about.
And
If
I don't
I
see that the
deny
fire
it,
marshal has said, yeah, that will adequately take care of the problem.
the building code determines that.
Mhm.
And so they'll review it, and there's a way to deal with it by putting in a firewall, pulling those eaves back, various other things that are discussed in the staff report. So they'll have to fix it if I approve it. If I
Mhm.
deny it, they have to fix it by taking that roof off and putting it back to the flat structure that was there before. So I understand the fire concerns, but those will have to be addressed one way or another because it's a life safety issue.
Okay. So, well, in any case, I think that if there ever is a problem down there and that the county is unable to, or the Estacada Fire District is unable to address the problems adequately, this hearing that we're having today is going to be exhibit number 1.
It
So,
might be.
yeah. And so that was my last thing, is that I think the county, by issuing these waivers, is exposing itself. And since I'm a taxpaying member of the county, then I am essentially exposed as well. So
Let me give you a little explanation. It's not a waiver. It's the
conditional
law
approval.
allows the structure that was built before the code to stay there, even if it's creates a fire hazard because it's too close. It doesn't meet setbacks. So, you know, if you're looking at the building, to the left is where the setback problem is. To the right is where the eaves are. So they're going to deal with the right-hand side. The left-hand side is too close to the neighbor's property, but because it was built before those setback requirements went in,
Understood.
they're allowed to keep it there.
Yeah, I understand that.
Yeah, okay.
Yeah.
So,
Okay.
and the addition, if it doesn't make that fire hazard any worse or other impacts any worse, then they get it's allowed to build the addition. So the issue before me is, does it make things worse? Fire, property value, other impacts that have been raised.
Okay.
Okay.
I think I'm done.
Okay. Thank you, ma'am. I appreciate your testimony. Is there anybody else who'd like to say anything about this application, or in support or opposition, or with questions or concerns? Please raise your hand. And I'm just waiting give everybody a chance to raise their hands. Not seeing anybody. Anything further from staff?
I don't believe so.
Oh,
Okay.
I would just,
Something.
actually, if
Ms.
you don't,
Nesbitt.
I just wanted to point out just a couple of things, if you don't mind.
Nesbitt, can we get your name?
Oh yeah, I was going to, yes, yes.
Okay.
I'm Lindsay, I'm Lindsay Nesbitt. I'm the planning manager here at Clackamas County, and I work with Maya. And I just wanted to reiterate, Mr. Turner, you just touched on this as well. The non-conforming use is the setback, not the height. And one of the considerations is, are there any greater adverse impacts of increasing the height? Not necessarily the height, but if you compare it to something like, if somebody built an accessory structure that met the setbacks, they could still build it the same height that this structure was raised to. So extending the height of this doesn't have any greater impacts than something that could be constructed that did meet the setbacks. So hopefully that's making sense. And the development rights of the property, it doesn't exceed the maximum building height as well. And then I think, yeah, you touched on the fact that it's state law and it's not a variance. And also just to reiterate, the wildfire maps were adopted yesterday for the state. They're still in the appeal period. So if this property does fall within that wildfire map area, it's, you know, that would be addressed at the time of the building permit as well, all of those additional standards. So thank you for letting me speak.
Did you say if it is within the wildfire maps?
Yeah.
Okay.
Yeah.
I thought, I just wanted to make sure.
Yeah. I don't know if it falls
Yeah.
within one of those areas. But I do know that most of the areas that are impacted are in the Mount Hood area corridor. So it's possible.
Okay. And I assume if you're in the wildfire mapped area,
Yep.
Different standards apply during building permit. Okay,
Yep.
That's what I thought. Just wanted to make sure I understood what you just said. And I can't read my own note. Just to say. Okay, thank you. Not seeing anybody else who'd like to testify. Mr. Stamp, anything further you want to add? And you're muted. There you go.
So for the record, Andrew Stamp on rebuttal. I didn't hear anything in the opposition testimony that changed any analytical point that I had. I actually thought that the testimony didn't really relate to the approval criteria at all. So I don't really have anything to say other than I stand by what we said in our case in chief, is that, and that was a good comment by Ms. Nesbitt. you know, with regarding non-conforming use and building height, it is non-conforming structure due to a setback and not building height. So that's a good point. I've only been on this case for about 3 days, so I didn't really have a whole lot of time to conceptualize some of that in my head. But one of the things we did while I was gone, I had my legal assistant email you that photograph. It'll look like that.
Okay, so on the right is the original, the current residence, on the left is the original garage.
Yeah, this is the original garage right here.
Okay. So it's
And-
not a flat roof, it's just a much lower pitch.
Yeah, it's hard to say exactly how much higher it is, but kind of looking at it there now, I'd say it's maybe 5 or 6 feet higher than what it was. I mean, you can use your own judgment, compare
Yeah.
the photographs, but maybe it's a little more, maybe it's a little less. I don't know exactly, but I was kind of taken aback by how little it was, how much, how little the difference is.
Yeah, I'm mostly interested in how the eaves extend to the left. Because that's where the setback issue is. It may not at all, but I'll review your photo.
Well, and I don't think this photo helps other than because it doesn't show the eave on the left. It's not taken from
Okay.
perspective.
Yeah.
But what it does show is that there is a small eave on the 3 sides that you do see.
Mm-hmm.
And it's hard to guesstimate whether it's 6 inches or 12 inches or what, but it is something. There is some, I'd say maybe a foot. And I think you could probably make the assumption that, whatever's in the front there. What is interesting is that the roof pitch is different. And I mean, not only the pitch, but the direction.
Really?
Yeah. So the ridge line of the roof now is, let's see, facing the river and facing the right of way. And previously it was the opposite way.
Can you show that picture again?
And Miss
It
Gander
looks
has,
like it slopes to the left and right of the structure, which it does now, doesn't it?
well, to me it's a 90-degree difference.
Really? Can we
Yeah.
pull up the photo, any photo of the, oh, there it is. I got it. Can you, I'll look at the digital photo that you've sent, and I think it'd be easier for me to see.
Okay.
Because yeah, right now, if the peak of that ridge, the ridge pole of the existing garage structure is perpendicular to the river, is that correct? Roughly 90 degrees to the river?
Yes.
Okay. And in your photo, you think it's parallel to the river?
Yeah, I think so. I mean,
Okay.
I'm just looking at the photo.
Yeah.
And kind of
It's hard to tell when you're holding it up. No, it's just the technology. So I'll look at the electronic one and we'll go from there. But I see your point.
But I think there was probably a foot around the whole thing that had a little bit of eaves around it. It's hard to say for sure, but that's kind of, I mean, looking at it and kind of just making a judgment call, more likely than not kind of thing.
Okay.
So anyway, I think that's really all we have. I don't see any particular reason to hold the record open. I think,
Well, I'll ask Ms. Johnson if she wants to respond to because that photo is new evidence. Ms. Johnson, do you want me to hold the record open so you can look at that photo and Mr. Stamp's letter and other photos? Do you want to?
Could you give me a couple of minutes to, or could I have it just left open for just like a few days?
If you want, sure.
Yeah, so.
That'd be fine.
Because I
want to give you the opportunity to review everything and respond.
Well, I worry about walking into any meeting unrepresented when there's an attorney in the room. And so, I might need to talk to somebody,
Okay.
but
How about a week? Does that work?
a week. Yeah, a week would be
Okay.
great. And
Okay,
then what
I'm
do I
happy
do
to
if
do that.
what do I do if I don't want to keep it open any longer?
I'll just hold it open for a week. I'll give the applicant a week to respond and
Okay.
the record will close automatically. So if you don't submit anything,
Okay,
we'll go from there.
okay.
Okay. So
Yeah.
thank you. And Ms. Nesbit.
So- Sorry, so if we do keep the record open, Mr. Stamp, are you willing, sorry if you were gonna ask this, Mr.
I
Turner.
was.
Okay, Mr. Stamp, are you willing to hold the clock for the record to be open? Okay, thanks.
Yeah, he'd said that already. and
I
was-
know, but
then
yeah, but then he
confirmation
just,
and-
yeah, I just
Yes.
want, you
Yeah.
know me, the clock is my concern.
I appreciate that
Yeah.
greatly.
I would represent you, not only that, but I wouldn't file a mandamus case. That would be more expensive to file than just, I mean.
I
that would
still
be-
don't want to violate it. Just.
Yeah. But I
Um,
just, I don't know. I'm not a big fan of the mandamus remedy,
Yeah.
except in the most extreme situations. So,
Okay.
the
So-
last mandamus I did cost 200 grand in attorney fees. So,
So, Mr. Stamp, I'll give you a week to respond. If the end of that week, nothing's submitted, you decide not to respond, you want to submit early, that's fine. I'll close it when I receive something in writing saying, close the record. And let me grab my calendar. We have specific dates we're talking about here for the open record and for the 150-day clock. Today is the 9th. So I will hold it open until January 16th. At 4 o'clock. I wrote it down and now I've lost my. Is it 4 o'clock for the
Yes,
county?
yes, it's 4 o'clock.
Okay, got it right finally. I do this in a number of jurisdictions. Everybody has the different ending times. So I'll hold it open until January 16th at 4 o'clock for anybody to submit additional testimony and evidence.
Yeah.
Anything
and
anybody wants to.
Yeah, sorry, I was just using the info that Maya shared. I'm gonna be quiet. I'm muting myself, sorry.
Anything anybody wants to submit has to be physically received by the county by 4 p.m. on the 16th of January. I'll give the applicant alone until January 23rd at 4 o'clock to respond if anything is submitted. If the applicant submits a statement earlier saying close the record, here's our final argument, or we're waiving final argument, I'll close the record at that point. I will try and get my decision out within 2 weeks after that. So anyway, February 6th, no. The 25th, yeah, that would be February 6th. Mr. Stamp, would you agree to extend the 150-day clock until February 13th, just to give us some room?
that's
And can
fine.
you say that on the record?
Yeah, fine. February 13th, whatever.
Wonderful. And would you submit something in writing to that effect today before 4 o'clock today, just so it's in the record? I think the state law requires that.
Okay.
So that's what I'm gonna do. So that will conclude our hearing. I will hold the record open, as I said, until the 16th of January for new testimony and evidence from anybody, the 23rd of January for the applicant alone. And that concludes our hearing. Thank you all. Have a good afternoon.
Thanks.